Well, hello, everybody. It is my distinct honor and pleasure to have with me today my brother, Solomon Radner, who name goes before him. He has gained quite some fame. And if you search Solomon Radner depositions, you will see a video with over about 1 million views on one of his depositions that he did. He actually didn't know about this, but one of his clients recorded it and posted it, and it's gone pretty viral. And there's some other depositions as well. He has appeared in state and federal courts in over 20 different states. He's been in criminal defense for over 14 years. He's tried dozens of cases to verdict, multiple states and jurisdictions. He's nationally recognized by National Trial Lawyers Association. He's been actively practicing civil rights litigation for the past 8 years, litigating the Fourth Amendment in at least a dozen different states. If anybody wants to get a hold of him, you can just go to the website, radnerlawgroup.com. There's a phone number there. You can also send an email with an inquiry to brothercounsel99@gmail.com. Well, Solomon, did I kind of summarize it all right?
You do your homework, I see. That's good to see. To be completely frank, it's nice to be on with Brother Counsel, particularly when Brother Counsel is my brother counsel. And being completely honest with you, it's been enjoyable watching your legal career grow from law clerk, from law student, to the prolific trial lawyer that you've become. And it's always enjoyable to sit second chair to you during your trials as well, and watch you do your thing.
Yeah, I mean, there's nothing more enjoyable than doing a trial together, which we have done a number of trials together, and that's always special.
We have, of course, the most special one is the one we did together with our dad, the three of us.
Oh, yeah.
And we hit pretty big on that one.
Yep. All right. Well, we've also lost our share as well, but we've won some, lost some, but we do our best to protect our clients' rights. So we're going to jump into the James Crumbley trial. And I'm not sure how much you're following it. I know that you've got quite a docket yourself. But it is in our home state of Michigan. It's in Oakland County Circuit Court, which I know you are very familiar with as well as I am, in front of Judge Matthews, which I know you have been in front of her many, many times. So I guess initially understanding that this is a 4 counts of involuntary manslaughter, which James Crumbley has been charged with, as well as his wife, Jennifer, who has been already convicted. Why don't you give a little bit of a flavor, since you've defended a number of these cases of involuntary manslaughter, give a little bit of a flavor of your approach, if it's different when it involves involuntary manslaughter as opposed to a murder charge or other crimes that you're defending.
So there are a number of things that you have to keep in mind when you're trying an involuntary manslaughter case as opposed to a first degree or even second degree murder case. And I'll just tell you some of them. I'll just kind of spitball here. The first thing that you realize is that on the one hand, when a jury knows that they're dealing with a first degree murder charge or a second degree murder charge, they know that a guilty verdict likely means that they're sending the person away for life. Whereas with an involuntary manslaughter charge, they don't really know how long they're sending the person away for. They don't really know how serious a conviction would be and how much time the person would do. And that obviously creates a challenge in and of itself, because for all that juries are instructed by the judge not to consider the sentence, they're still human beings, and of course they're going to consider the sentence. So obviously that's going to be one thing that you have to keep in mind, is that you have to make sure that the jury understands that this is a murder charge. And that's why when I would refer to an involuntary manslaughter charge during a trial, one thing that I would want to make sure to do is to constantly refer to it as a murder charge. This is a murder case. My client is on trial for murder. That's something that you want to make sure the jury understands. This is a murder charge. There's no other way around that. Mm-hmm. On the other hand, the juries also, kind of similarly along the same lines, juries may be more easily convinced that somebody committed, for example, gross negligence, as opposed to the specific intent of committing a murder or the actual intent of committing a murder. I think that oftentimes people are just more easily convinced that somebody acted negligently without realizing that gross negligence is also a very high standard.
Yeah, well, that also brings another point, is that when you're proving intent and, it's the person that has the gun in their hands, it's a little bit easier to draw that conclusion as opposed to take a case like the James Crumbley case that we have in front of us today, where the allegations are that he didn't appropriately secure the gun, didn't get his child perhaps the mental health intervention that he needed, where it's not as clear cut as the person pulled the trigger. Now the question is whether he actually intended to do it or intended for this murder. So I guess it also can make it a little more complicated to the jury when you're talking about a involuntary manslaughter where where the standard is gross negligence.
That's very true. And I watched both opening statements. I have not been watching the trial like you have, and I've seen some of your analysis. It's funny, over the last several weeks, I've watched more and learned more about a number of trials that have been going on from you than I have from the actual trials themselves. And ordinarily, I know you know this, but I know a lot of your viewers don't know this. Ordinarily, I'm a bit of a trial junkie. When there's a trial going on, I kind of have it either on in a corner of my computer or a TV in the corner of my office. I always enjoy watching trials. There have been a lot of trials that I've watched almost beginning to end, and I always enjoy it. But lately, I've been, like you said when you started this video, I've been a little bit busy with my own docket, and I have not been able to follow them. But anyway, I say all that to say that I did watch the opening statements, and I think that the prosecutors in this case, I know Mark East, I've had cases with him, and I know that Karen McDonald is a prolific jurist. She's absolutely one of the best. I knew her when she was a lawyer. She was a partner at a very prominent firm. Then she became a judge, and now she's the prosecutor of Oakland County. And she is an absolute force to be reckoned with. She's very passionate about what she does. She is exceptionally competent, and she really knows how to lay the facts out. And Mr. Keast also has been doing an absolutely amazing job. When they did their openings, and I don't know if you have specific outlines of how you're going to be going through this. I'm kind of following you on this.
Yeah, that's fine. Speak your mind.
Okay. The way that the prosecutor laid out the facts of the case and the way he wants the jury to interpret those facts to make a finding of gross negligence was beautiful. It was like a hand in a glove. It was really, really well done. And the defense attorney has a very, very high hurdle. Not only is this case all over the news, her client was vilified, certainly made to look like the bad guy here, and all of the evidence that's been put out in the news obviously is always a major uphill battle. Anytime you have a case that's high profile and involves the media, it's always very difficult, and it's very tricky to know what points to hit and what not to hit. But I thought the defense attorney also did a very fine job given all the hurdles that she had to overcome.
Yeah, and something that I mentioned, I thought that she made some pretty decent arguments and some points also, but some of the things that I mentioned in my video on the opening statements was the fact that she did not talk about the burden of proof, which is that they have to prove beyond a reasonable doubt, as you know, and also the fact that the gross negligence wasn't clearly explained, which I think, especially in a trial like this, going into where gross negligence is not so clear, and like I said, like with intent, I think it's a little easier to swallow, where gross negligence is a very high burden. And I think it would have helped her if she would have explained that to the jury, how high of a burden not only beyond a reasonable doubt is, but also gross negligence, how much worse it is than ordinary negligence, and how the jury can find that someone could be negligent, in this case, James Crumbley, and still have to write not guilty on the verdict form. So I thought that was an important thing to be stressed during opening statement, and maybe she has reasons why she didn't. But did that stick out to you as well?
That did stick out to me. In fact, those two things in particular stuck out to me. Her opening, and this is common with defense, her opening was very short and it was very pointed. And the reason you do that is you don't know exactly what the evidence is going to show. The prosecutor does. The prosecutor spoken to all the witnesses, and the prosecutor knows exactly what they're going to lay out. The defense attorney can either make an opening statement right after the prosecutor, or the defense attorney can wait until the prosecutor is done presenting her case and then make an opening statement and then put on her evidence.
Have you ever seen that done?
I've done that.
Oh, really?
There are very specific strategic times where that's something that you may want to consider doing. I don't think this is a case where that should be done. This is a case where you have to hit you have to hit it immediately. Prosecutor makes her opening statement, you got to make your opening statement. This is not where you would want to do that is, for example, if you have a witness that's going to say something that you know about or that you think is going to present evidence in a way that the prosecutor may not put it on. The best example for a criminal case is if you have, let's say, your client is going to testify, and you know for a fact that your client's going to explain certain things that nobody else is going to be able to explain. You have you already know what the prosecutor's case essentially is because of the discovery rules. The only testimony that can be at surprise at trial, typically speaking, is the defendant's. So if you know that you're going to have your client and your client's going to testify and really make a major point, then that might be something where you want to wait and wait and wait. And then after the prosecutor rests, then you get up, you make your opening and you say, ladies and gentlemen, I'm going to tell you something. My client's going to take the stand and he's going to testify. I've done that twice my entire career. I've been involved in hundreds of criminal cases. I've tried at least several dozen to verdict. And I've only done that twice, where I'll say to the jury in my opening statement, my client is going to take the stand and tell you A, B, and C. And it's very strong and it's very powerful because during jury selection and during opening statements and during the initial instructions from the court, what's one thing that the jury hears over and over and over and over again? My client has the absolute right to remain silent, and that silence cannot be used against him. And that's why it can be very powerful to do that. Now, in this case, what the defense attorney did is obviously she knows the case better than we do. She knows the facts, and she probably knows the law better than we do because she's been researching it for this particular case. And this is, I believe, a first in the nation type of case. It's certainly an interesting and new legal theory. But what she did was she presented it the way that she felt was most effective. I thought she did a very fine job, but I would tend to agree with you that she probably could have stressed a little bit more about what gross negligence is and how the evidence in this case will not rise to that level, is specifically addressing some of the things that the prosecutor said. The prosecutor laid out his case beautifully, really, very beautifully. And what you want to do at that point is poke a hole or two into it.
Yeah, something that I mentioned in the Jennifer Crumbley trial when I was covering that is that it seemed to me that the defense attorney was trying to make Jennifer out like a regular, ordinary good parent, and I questioned that because there are certainly questionable things that she did, and if you're going for the home run and saying she's the perfect parent and it could be me sitting in that chair instead of maybe she made some mistakes. Maybe she's not the perfect parent. Maybe she was even negligent, but that still doesn't rise to gross negligence. I thought that might be a little bit easier for the jury to swallow, and maybe that's what should be done for the James Crumbley trial. Another point that you brought up is that Jennifer Crumbley actually took the stand in her case. I don't know if you know this. She actually took the stand, and she was on the stand for a while trying to explain everything. I guess everyone's going to be kind of wondering, I wonder if James is going to be taking the stand. And you said that most of the time your client does not take the stand. Knowing what you know, again, of course we don't know everything, but knowing what you know from this case, you think it would be a good idea for James to take the stand or not to take the stand?
That's a decision that's usually made during trial. That's a decision that's usually made after the prosecutor rests. What I like to do in preparation for trial is I meet with my client, we go over the discovery, we go over the evidence, go over whatever transcripts there are, and go review with my client what his or her testimony would be. And then kind of make bullet points of what points we want to address. Everything has to be pointed. There has to be a reason that you do things at trial. And so what we would want to do is make sure that we understand what that testimony would be, and then see how the case plays out. There are times where I'll meet with my client and I'll say, I think you got to testify. And there are other times I'll go to my client and say, I don't think you should testify. And there are times where my client will say, I don't care what you say, I'm testifying, put me up.
Right. So it could be at this point of the trial, they didn't even make that determination yet.
I'd be very, very surprised if they absolutely are 100% one way or the other. Just from seeing what I've seen, I would have some concerns about putting Mr. Crumbley on the stand.
Mhm.
I think putting Mrs. Crumbley on the stand was risky enough, but I think putting Mr. Crumbley on the stand with the prosecutor, well, very often when a defendant gets up to testify, prosecutor just starts to lick their chops because they've got a whole binder that they prepared, things that they know, misstatements that were made, false statements that were made. They've got everything just ready to go, and they wait for that person to be done, and then it's like a punching bag. And I've seen that happen. I've seen that happen where it's just punch after punch after punch after punch. And there's, you know what you can do as your lawyer, as the lawyer of the defendant while you're watching that happen? Nothing.
Exactly.
You just got to sit there and watch the show.
Exactly.
And
Well, here's a question.
Not fun.
Here's a question from Jane says, I'm done. Isn't proving negligence like proving a negative?
I don't think it's proving. No, it's not proving a negative. It's proving that somebody acted negligently.
Yeah.
Proving that somebody did something which violated a standard of care is not proving a negative. It's proving that they did something which violates a standard of care.
Yeah, and just to add to that, there could be you can prove it by either actions or failures to act, omission. Right. So that technically could go into that. Another question from.
One second, let me just add one more thing. Proving it by way of failure to act is not proving a negative. It's proving that somebody did not take an action that a reasonably prudent person would have taken.
Okay, so maybe that clears it up. Another question from Jane says, I'm done. Defense doesn't know evidence. Isn't the prosecution required to turn it over?
Okay, so let me explain that a little bit better. You don't know how the evidence is going to come out. What you know going into the trial is you know the entire universe of what the prosecutor may present. You know that there's, like, for example, something that I deal with when you have a client who's in jail is you get jail calls. There was one time during a murder trial where I was given several discs of jail calls that took place during the jail that the prosecutor just received from the sheriff, and she gave them to me. And I had to spend the entire night listening to them because I didn't know which ones, if any, would be played. And I had to be prepared for them, should they be played. There's another reason that you got to be very careful about your client testifying is that they may not realize that they said something and they're going to say something under oath. And then the prosecutor is going to be ready, play clip 45. And I had that happen one time. It was, I would say comical, but there was really nothing comical about it. Every single time this person testified, every time he would say something, the prosecutor would say, roll this clip, roll that clip. And there was actually one call all the way at the end of the trial where the person is talking to a friend and talking about the trial. And he says, I can't even get anywhere because every time I say anything, the prosecutor says, play this clip, play that clip. And the entire jury just burst out laughing.
Okay, something that maybe you noticed also during opening statements, and I know that some of the people are wondering about, is that the prosecutor said that we're not able to call Jennifer to the stand and we're not able to call the shooter. We're not going to refer to him by name. We refer to him as a shooter. So why is that? Why can't the state call Jennifer? She's been convicted already. So is that true or not? Why can't they call Jennifer and why can't they call the shooter?
So there's a couple of reasons that could be. Okay, one of the most obvious is the Fifth Amendment protection from obviously from being forced to testify. But since she already testified, that most likely does not apply here. However, there is a spousal privilege that could very well apply in a case like this, and either spouse could invoke it. And if that's what's going on here, again, I haven't researched spousal privilege in quite some time. I did have a case recently, but it involved it was a case in which the husband and the wife was the alleged victim of the alleged crime. So in that type of case, obviously it can't be invoked. But to have one spouse testify against the other, my last recollection and my last research of this is that can't be compelled. As far as the individual goes, again, I don't know if
the shooter.
I don't want to say
the shooter.
The shooter. As far as the shooter goes, I just don't know offhand if it was a guilty plea or a no contest plea. And then also, for as long as there's going to be appeals, most likely they're going to be able to invoke the Fifth Amendment. So it could be that there were motions in limine done about that, which is essentially where a party will file a motion and ask the judge to make a ruling. And once that ruling is made, it doesn't matter who made the motion and who argued it. Once the judge says this is going to be the law, then either side could tell the jury, this is what the judge said is going to be the law.
Okay, here's a question, which is interesting. This is from SP 74. Can you speak to gross negligence versus willful disregard? Really, my understanding is that it's actually pretty similar. Gross negligence is willful disregard. In my understanding, I think that there's different legalese that different jurisdictions define it as, but essentially, I believe it really is willful disregard. What do you think, Salman?
They're very similar. Realistically, and this is something that comes up all the time when parties are arguing about jury instructions, realistically, it doesn't make a difference. If the jury would find guilty of one, they would find guilty of the other. And if they would find not guilty of one, they would find not guilty of the other, meaning whichever terminology is used. The general, and again, I haven't researched this very recently, but gross negligence is basically that that you were indifferent to something happening and that there was a likely result from your indifference. And what was the other term that was used?
Willful disregard.
Willful disregard is a little bit more of a deliberate action. It's where you know most likely that this is going to be the result. So like I said, very, very similar. Legal scholars could probably explain the difference, but the reality of the situation is that it doesn't really practically make a difference. They're basically the same thing.
That's just reminded me that what you were talking about before, how the penalty can be different and depending on the charge, whether it's involuntary manslaughter versus murder. I know that in the Hannah Gutierrez Reed case, that was with the Alec Baldwin shooting, the Rust production.
Yep.
On that one, the maximum I believe she's facing is 18 months. And in Michigan, the maximum I believe is 15 years. So very, very wide difference there between, where you are. So, whether the jury actually knows it or not, it's a good point. It could make the difference between their voting guilty and not guilty. Let me ask you another question. Something that came up a few times, and I was thinking about myself, is that there's in this trial, the James Crumbley trial, and also in the Jennifer Crumbley trial, there's been admission of some of the videos of the actual shooting and pictures or videos of the victims lying there that they don't show to the public, obviously, but the jury's seeing all that. And the question really is that in this type of case where it's not the trial of the shooter, it's the trial of the parents, which is just the question of whether they secure the gun or not. Why is that relevant and why does that come in? And I'm sure that there's been motions filed about it, but the judge is allowing at least a limited amount of admission for these videos. So what do you think about that?
Very good question. I don't know if motions would have been filed about this. I think there's a good chance that motions would not have been filed about this, though it's possible that they were, and I'll tell you why. Very often in murder cases, almost always in murder cases, the prosecutor is allowed to introduce evidence of the murder. And if that evidence of the murder is a picture of the dead body, a picture of a bullet-riddled body lying on the ground, blood all over the place, and gore and guts and brain matter, those pictures very often come in. Now, I will tell you, I had one murder case that I worked on where a pregnant woman was killed. And the prosecutor wanted to introduce a whole bunch of very gory photos. And one of the gory photos was the woman lying on the ground, dead, full of bullet holes. And another picture that she wanted to show was after the autopsy was done and they noticed that she was pregnant, they had a picture of the fetus. And this must have been probably a 7 or 8 month baby at that time. So it looked like a baby. It looked like almost like a full grown baby. You could definitely see that it was a baby. And the prosecutor wanted to introduce that picture. And I didn't even say a word. The judge looked at the pictures and said, that's coming in, that's coming in, that's coming in. That one's not coming in. No way. I didn't say a word. There were no motions filed. There was nothing. It was, here's the proposed exhibit. And before anybody could file anything, the judge said, yes, 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 no. Simple as that. Now, why do prosecutors do that? They're allowed to try their case. It's a murder case. It's tragic. And one of the elements is that a death took place. They're therefore allowed to introduce evidence that a death took place. And if that's dead bodies and pictures of gore, they're going to do that. Now, a reason that some prosecutors do that is to evoke emotions, to make the jury feel anger, sympathy, sadness, the need to dish out some justice. And when prosecutors do that, and when they show pictures that I feel are just unnecessarily gory and sickening sometimes, what I'll do is, instead of arguing that it shouldn't come in because it's almost always going to come in, is instead I'll argue to the jury why. I'll show them the picture in my closing. I'll say, take a look at this picture. It's hard to look at, isn't it? You could see a person full of bullet holes. Say, why did the prosecutor introduce this picture? We all know that Mr. So-and-so was killed. We're not contesting that. At no point in time did we contest that. And yet, for some reason, the prosecutor felt the need to show you this picture. Why? For one reason. Because the prosecutor wants you thinking emotionally. The prosecutor wants you to be emotionally charged. And the reason the prosecutor wants you to be emotionally charged is because he or she knows that that's the best way to get a conviction. But that's not right. That's not what they should do. They should rely on the evidence. Now let's take a look at the evidence. So let's put this picture down and let's look at the actual evidence, or perhaps lack thereof. So again, these are arguments that are made on a case-by-case basis. But as far as terrifying and hard to watch pictures and videos, they come in all murder cases. That's just the reality of it.
So I think that they're being admitted for a limited purpose. I don't know if she's allowing every single video in, but certainly enough that can evoke, I guess, some sympathy. Also, what do you think about? I know that you've tried a bunch of these cases, but what about when you have the family members there sitting in the gallery, and the jury sees them there every single day. They know exactly what they're there for, and what type of pressure does that add to them in the jury room? And I guess as the attorney trying a case, have you ever spoken about that, or have you ever spoken to juries afterwards about, what if their presence caused anything, and what about you're the defense attorney and you're representing, the person who's being charged with these crimes, and you're passing them every single day. Have you ever had any interactions with them, and do they kind of understand, or are they upset at you? Like, how does that work? So I guess it's a loaded question, and it's a compound question, and you can object all you want, but there it is. So,
okay. So very good question, by the way. The answer is that it's open court. Anybody's allowed to be there. I had one case that I worked on probably about 10 years ago where my client was a police officer, completely innocent. We won the case, filed suit, and made a lot of money for him. Going into that case for the trial, there was nobody on the prosecutor's side of the courtroom. And on my side, I had 8 or 9 uniformed police officers sitting right behind me every day, making sure that they were there supporting their friend. This is just one of the things that people do. Every juror that I've spoken to says that it doesn't affect their decision at all. Does it? Does it not? I kind of find it extremely hard to believe that it never would affect them at all. But it's open court. Anybody could be there, and family's allowed to be there. As far as passing family and having to talk to them, there have been times, obviously in a murder case, it's much tougher, but there have been times where the families are very professional and very understanding. They understand that there's a process, and they don't have a problem with me, even though I'm defending somebody who they believe is a murderer. There have been other times where family members have threatened me implicitly, explicitly. I had one family member follow me out of court one time. It was a particularly difficult case. My client was charged with 6 counts, including a couple of attempted murder counts, and he was found guilty of an assault, and he went to prison for, I think, 11 months, maybe 12 months, something like that. Not a tremendous amount of time. And prior to trial, the offer, I think, was 8 years. And the prosecutor made it very clear that should we go to trial and lose, he's going to do 20 years. So as I was walking out after that verdict, one of the alleged victim's family members followed me out and was threatening me. But it comes with the territory. I can tell you that, generally speaking, criminal defense attorneys are not an intimidated bunch. And if you're gonna do the work, you got to be prepared for that kind of thing.
Okay, well, a little bit easier to just, I guess, file suit against an insurance company. All right. So here's another thing that came up in the Jennifer Crumbley trial, which I haven't seen it come in yet, but we're only up to, I think it was the 3rd day of trial today. And this specific witness wasn't called yet. So we'll see if it does happen. But in Jennifer's trial, Brian LaRoche was called to the stand. Brian LaRoche was a good friend of Jennifer. And
he was the one who had the affair?
Yeah.
Okay.
Yeah. So And now, and what became clear during trial of Jennifer Crumbley is that the defense filed a motion in limine to preclude any mentions of the affair. That's what it seems like. I didn't read the motion, but that's what it seems it came out during trial. And the judge granted that motion, which meant that when the prosecutor has Brian LaRoche on the stand, he's not to ask any questions about the affair. And what I've noticed actually when I was watching that was that the direct examination was very short and really just went over some text messages that they sent back and forth. And yeah, there were some things that were incriminating, but it was just basically the text messages, just basically authenticating the text messages, it seems like. And on cross-examination, the defense brought up that he was involved in 3 different police interviews, and she was setting the foundation, at least, for the argument to be made that he was intimidated and he was threatened, not specifically, but between the lines, with them taking away his pension, and if he sides with Jennifer, then things, he can lose his job, lose his benefits, things like that. And she was trying to bring out that that's why he was, I guess, sharing more information than he would have. And once she started this argument, the prosecutor jumped up and he let the court know that if she's opening the door, then he should be allowed to explore, without saying it in front of the jury, he should be allowed to explore the affair. And the Judge Matthews, dismissed the jury, and they had some oral argument. And the defense attorney essentially said, you know what? I don't care. Let the affair come in. I want this part to show that he could have been threatened or felt threatened with his pension and benefits and things like that. And that's why he gave some damning evidence against Jennifer. And then, the question, I was just thinking as strategically as an attorney, a trial lawyer in that situation, is that something that once the jury hears that they're going to be so biased against Jennifer now, it's just like another thing to throw on her that she doesn't need? Or was it the right move that you want to show that he was biased in this way? And to be frank, the prosecutor kind of rehabilitated him pretty well and said that he never really felt threatened that they're going to take away his pension, and all he had to do was say the truth. So I was kind of, I guess it's one of those tough situations. I just wanted to get your impression about that whole back and forth. And what do you think, I guess, in this type of case, involuntary manslaughter case, where there's going to be some evidence about an affair, which can paint Jennifer in a certain light, if that could affect the jury enough to see the evidence differently, or see Jennifer differently, or just too much to allow come in. So I spoke enough. Now you can take it.
Well, let me make sure I understand this from a high level. So this Brian fellow had an affair with Mrs. Crumbley.
Jennifer Crumbley, yeah.
Okay. And obviously Mr. Crumbley probably is not happy about that, I would presume.
Well, he wasn't in the first trial, so we don't know, but I'm assuming, you would assume that he's not so happy about it.
And we're talking about right now, Mr. Trial or Mrs. Trial?
Well, I want to know your opinion about that trial first, about the Jennifer trial. Whether, if you were representing Jennifer, is that something that you would say, you know what, I don't care, as long as I can completely cross-examine this witness and show that he may have been biased because he felt not biased but pressured with his pension and benefits and things like that, then I'll allow the affair to come in, or you don't want the affair in no matter what, and therefore just stop what you're doing right now, and then they won't be able to bring up the affair, and then we'll get to the James Crumbley trial.
Okay, so again, without knowing all the facts and all the details and all the evidence, which obviously I don't know in this case, just from a high level, the things that I would want to consider are, number one, what is it that I'm trying to get out of this cross-examination? So if I already get out of him that he was pressured by the police to say these things, and then the jury goes out, and now the judge tells me, if you continue this, they're going to be able to bring up the affair, I'd probably at that point wrap it up, because at that point I already scored the points that I'm going to score, which is that the police intimidated this man and pressured him, if that's my argument and if that's my point. And by bringing up the fact that she had an affair, that certainly makes the jury dislike her. Every fact that the jury hears, they're either going to say there's a good person, there's a bad person. It's sometimes referred to as the halo effect. You put a halo on somebody, or you put the devil airs on somebody, the devil horns. And when you hear, and then when they hear a fact, they try to squeeze it into either the halo or to the devil. That's just what they very often try to do. So in Mrs. Crumbley's trial, if I already scored the points that I'm going to score by pointing out that he gave 3 statements, that the police pressured him, that they threatened him with his pension, and now the judge tells me, okay, if you continue the affair, because I'm coming in, I'm going to get the extra points I'm going to get by being able to continue that cross-examination. I think I lose by the fact that now they're going to hear that she cheated on her husband. Okay, so now that's for her trial. For Mr., what I'm thinking is he's going to look like a victim. And again, the jury's going to hear this. They may feel bad for him. Not only that, they may feel in this type of a case, they may think that she wore the pants in the house, that she was in charge, that she kind of was in control. If she was the one having an affair on him and he was coming back home to a woman who was cheating on him, then not only does it look like he's, frankly, a little bit pathetic, that she's in control of him and she's in charge and she's the one having affairs and he's not, it kind of makes it look like she's wearing the pants, and it also gives him a little bit of sympathy. So I would think in his case, I probably would want it to come in. But in her case, I would do whatever I could to keep it out. And again, this is without knowing all the evidence. It could be that the lawyers, whatever it is that they did, had reasons to do whatever it is that they did. And again, you probably know what each one did. I don't. I haven't looked at the case to the level that you have.
Yeah. I thought that needed. It seemed like she actually kind of made the decision on the fly, which, I would have to be careful with that. Maybe she thought about it, but I was just wondering. I was like, I would need some time to think about that. All right. Here's another question. This is from Blurry Lights. Prosecutor mentioned proximate cause. How close to the crime do the parents' acts have to be considered a cause? And I like the way that she, Blurry Lights, wrote a cause, not the cause.
Mm-hmm.
So what do you have to say about that?
So this is the but-for test. The but-for test is, but the but-for test is a part of this. Had this not happened, would this have happened? Is essentially what proximate cause means. It means that they did something which proximately caused the next thing to happen. It's basically that one was a direct consequence of the other. All right, dominoes is obviously the easiest thing. You push one domino, the next domino falls. Right? Then there could be something called an intervening or superseding cause, and that's where proximate cause could be broken. If you do something, and because of that, something else happens, which you have no control over, and it did not directly cause that next thing to happen, then that would not necessarily be proximate cause. But generally speaking, proximate cause means that you did something, and the direct consequence of that happening is that the next thing happened.
Was it you that had the trial where you used the dominoes? Was that you?
The judge didn't let me. I wanted to. But those have been done. I forgot the causation dominoes they're called.
Right. And I think that, I guess, to answer the question a little bit more clearly is that it doesn't have to be so, proximate sometimes can mean close, but I think in the legal sense, it doesn't necessarily mean that it was close to the actual act, but it's a legal cause, a legal reason that we can stick it on you. So I don't think it has to be so clear, so close to the crime. Let me show you a clip. There was been testimony by the assistant principal named Christy Gibson Marshall, and what she did in this case is just mind-blowing. It's mind-boggling. There was she was in Oxford. She was in the school when this happened, and they went on lockdown. They called out lockdown. Everybody knows exactly what to do on lockdown. That's why all the schools have lockdown drills and everything like that. So instead of her going on lockdown, she went to check the hallways. She wanted to make sure, I guess, all the students were safe and in.
During the shooting, she went to check the hallways?
This is during the shooting.
Wow.
She went out. She did not go on lockdown. She went out to look.
And she survived?
Yeah. She testified.
Wow.
And listen to what happened. What happened was that she actually went to one of the hallways and saw one of the students on the floor, Tate Muir. And that was, she said that she checked him and he had a pulse, and she tried to resuscitate him, but her efforts were not fruitful.
With the shooting still going on?
with the shooting still going on. Now listen to what happens.
Woman's an angel.
The
What's her name
shooter,
again? Christy what?
Christy Gibson Marshall.
Wow.
So what happens is that the shooter actually starts walking down the hallway where she is attending to Tate Muir. And she looks at the shooter. They look at each other. And let me see if I have this clip for you.
This is while she's doing CPR?
Well, I guess either she was in the middle of it or she gave up at that point. I'm not, it wasn't clear. But let me show you the clip. And then I want to show you something that maybe even the defense attorney can use.
Wow.
Okay, tell the jury what you did.
The shooter was coming closer to me. As he got very close, I realized it was Ethan, and it didn't seem right to me because Ethan always seemed like a sweet kid. I just couldn't picture that being him, so I talked to him. As he walked by, I asked him if he was okay, what was going on. I took a few steps down the hallway with him.
Did you see that he was holding anything?
Yeah, he had a gun in his hand.
So,
Wow.
so you see that she was actually interacting with him, and she says, "Are you okay?" He had a gun in his hand, and essentially he just ignored her, and they actually walked a little bit together, but he didn't shoot her. So what I was just thinking, as there was no cross-examination on this witness, and you can, I guess, understand why. Like, this is a real special woman, and you don't want to start attacking her, when you're representing James Crumbley. But I thought, and this is just me thinking, she did say in that clip that she never would have thought the shooter would have done anything like this, and that she knew the shooter as a sweet kid. And as a defense attorney, wouldn't you want to cross-examine her, not be mean, just say, hey, you just testified, the students very well, you're the assistant principal, you make it a point to have a relationship with all of the students, and you knew the shooter, and you thought that he was a sweet kid who would never be able to do such a thing. Wouldn't you want to cross-examine just on that point and let the jury know, hear that again, and then you can come back in closing and say, if she didn't know, then why should we assume that the parents knew anything more? Now, of course, the parents knew more, but here, at least you have a principal saying that she thought that he was a sweet kid. So what are your thoughts about the whole line of cross-examination, and how would you deal with this type of witness?
You're saying in this case there was no cross at all, not a single question?
Not a single question on cross.
Okay, so let me just tell you this. Something I remember hearing very early in my career from one of my mentors was the toughest lesson that every lawyer has to learn is to know when to shut up. All right? It's not easy for any lawyer to do. Just look at us right now, just talking here on YouTube about a case we're not involved in. Lawyers love to hear themselves talk, especially about an issue that you think you can win. This is definitely, in my opinion, that line, and that jumped out at me also as soon as you played it. That jumps out as a win for the defense, because what she's basically saying is that I was so surprised it was not him. I didn't think that would be him. Whatever the exact verbiage was, she was surprised that the shooter would be doing this. Now, this is a case where the prosecutor has to prove beyond a reasonable doubt that the parents essentially were on notice that this was most likely to happen, that they acted with reckless disregard for the victims. But when you have a prosecutor's witness, who I guarantee you every single person on the jury thinks is a hero, just from hearing her 1 minute of testimony you just played and the background that you gave me, this is the woman who's going to get that halo. Okay, the jury, they could hear anything. This woman's going to have a halo, and no matter what you do, she's going to be an absolute angel from beginning to end. And frankly, she is. That's well deserved. Okay, so on the one hand, if you get up and try to cross-examine or let's say bring that point up again, ma'am, let's just go over that again. You're saying you were surprised that the shooter would do this? Yes, I was surprised. Okay, great. And then you sit down. You made that point. You just drilled that point home. You know what that does? That gives the prosecutor an opportunity to get up and say, Well, why were you surprised? Were you really surprised? Well, yeah, I guess I really wasn't that surprised. I guess it was more shock than anything else, or some other way of justifying what she said. You can't gain anything by talking about it more. You got what you needed. Like I said, have your points, the points you want to make. You made that point. Now don't bring it back up. What I would do with that is, in closing argument, I would tell the jury, I would show them gross negligence. I would show them that the standard is reckless disregard beyond a reasonable doubt. And now what is beyond a reasonable doubt? The judge is going to tell the jury it's a doubt that you can attach a reason to. Well, let's talk about doubts that you can attach a reason to. Christy, who's nothing less than an angel, testified that she was surprised by this. Is it really that much of a leap to say that the parents could have had some doubt as well? Maybe that's a doubt that you can attach a reason to, that they were also surprised. They would have been shocked if to learn that their son was the shooter. So I think this was very well done by the defense by not standing up and saying anything, even though that's clearly a point for the defense.
Mm-hmm. Okay, well, so I guess, yeah, so you would not have cross-examined them and just brought it up on closing argument. Right, see, sometimes a lawyer has to know how to stop speaking. Well, with that in mind, I think that's a good cue that maybe we should stop speaking. I'll just, if anybody has any questions, I'll look in the chat for another minute just to see if anybody wants to ask any questions before I let the Solomon go, the national trial lawyer.
Thank you for that intro, by the way. That was very nice of you.
Well, you've been in a few more states than I have, so you deserve it. I just practice in Michigan, and as you know, I just got licensed in New Jersey recently, so we'll see if I do anything with that. But
I guess it's good to know that at least my brother thinks I'm a good guy.
Okay, let's see. Here we got a question from SD. James got in trouble last week for threatening a witness via phone.
Oh.
How would you handle this if this was your client? So this happened. I didn't know. I guess that there were some reports afterwards about exactly what happened, but it seemed that the attorneys were hesitant to talk about this in open court. The defense attorney wanted it to be more of a sidebar. And it seems that they entered into some gag order that James is not allowed to speak to anybody but clergy and his attorneys. It seems that, according to SD, and maybe this is what the reports say, James got in trouble for threatening a witness. So if this was your client, Solomon, what would you do?
Okay, well, question number one is, did the jury hear this?
No, it doesn't seem that way. Well, actually, no, the jury did not hear this, but the judge made it clear that anything that's about to be said in open court is going to be front page news in the next 10 minutes. So,
right.
They're trying to dance around that a little bit.
Well, it depends. It depends. I've had this come up in a number of different ways. I had there's one case in particular I recall where my client was out on bond, and one of the witnesses came forward and said that his tires were slashed, his house was shot up, and something was lit on fire. Maybe one of his garbage cans were lit on fire. And I was there for a status conference, and they sprung that on me, and I had to deal with that. And I forgot exactly what exactly I said and how I argued it. But I do remember that my client stayed out on bond with a tether. So I don't remember exactly all the details of that, though. I mean, look, if the jury's going to hear it, you got to deal with it.
Right,
it's something which is very case specific and fact specific. Sometimes it's just an allegation. Sometimes it's not really threatening or intimidating. Very often it's nothing but hearsay. And if you can actually cross-examine somebody about it, it comes out that it wasn't really a threat. They just took it as a threat, and he didn't really say anything that bad, but because of everything that was going on, it was just misinterpreted. It would all depend. My number one thing would be to make sure the jury doesn't hear it. And obviously with a case like this, I assure you the judge is going to instruct the jury, and probably already did instruct the jury, not to even pick up their phone and check Facebook, okay? And whatever other things people check nowadays.
That's what they
don't check social media. Don't read the news. Nothing. If you're at a family dinner and people are talking about the trial, tell them you're a juror. And if they keep talking about it, go home.
And Solomon, I don't know if you know that some of these other cases just recently, there's been some motions filed after the verdict based on some jurors that have been going on to social media and watching shows like mine, where they're hearing, a lot more about the case than they should be, or hearing different analysis on the case. So this is becoming an issue that's been creeping up more lately. And I know the trials that I'm watching now, the judge is always warning the jury to stay off social media, stay off all this stuff. I'm just going to show this question for completeness sake. What was dinner time like at your house growing up? But I'm not sure if we want to go there. So let's move on.
Answer that. This. My dad's a trial lawyer too. So we certainly had, and there were 9 of us. There's 9 kids in our family.
9 kids and 10 opinions. Yeah, it was.
That's right. So we certainly got into it. We had very heated arguments, but thankfully we're all very close. We all love each other very much, and we still have very heated debates every time we get together. It's a lot of fun.
Right, just not when we're on the same side of the trial room. All right, courtroom. What kind of law does Solomon practice?
So the majority of my practice is civil rights. I've litigated the 4th Amendment probably in at least a dozen states. And that's what
Why
the
don't you
majority.
explain a little bit more about the 4th Amendment so people understand that?
Okay, the 4th Amendment is warrants, search and seizure, unlawful stops, excessive force, things of that nature, false arrests, malicious prosecutions, false convictions, things of that nature. That all falls under the umbrella of civil rights. But particularly 42 USC 1983, which is the federal statute that allows you to take action against a law enforcement officer who engages in some sort of misconduct. There's a lot of misinformation out there about what qualified immunity means. I'm not going to get into that right now. All I'll tell you is most people who I've heard their commentary on qualified immunity get it wrong. All right, it's not as absolute as some make it sound, and it's not as, and doing away with it is certainly not what others would suggest. But prior to that, and still, I have always done criminal defense. When I first started my practice, I focused almost exclusively on criminal defense, and I still do a lot of criminal defense to this day. Just now, I'm much more selective about the cases that I get involved in, and because the majority of my practice is civil rights.
All right, Solomon, you see this one from DeCullough DK?
Lawyers encourage their client to take a plea if the facts against them are bad. Very good question, and like you're probably going to guess just from hearing me for the last 45 minutes or so, it depends. It depends on your client. It depends on the facts. It depends on the evidence. It depends on your jury pool. It depends on a lot of things. Depends what evidence you have. If the facts are bad and the evidence is bad, then yes, I will strongly encourage my client to take a plea. That's just the reality of it. What's sad is when they're innocent, and this is, in my opinion, one of the most abusive things that some prosecutors do. It makes me sick. When some prosecutors know that they're prosecuting an innocent person, instead of dismissing the case, what they'll do is they'll make an offer that no sane human being can turn down. So like if somebody's facing life in prison, they'll reduce it to some no contest plea of some misdemeanor that's going to be wiped off their record in 6 months. I've seen unethical prosecutors do this. It's disgusting. But that's what they'll do instead of dismissing a case. And I've seen that happen. And sometimes they'll just get up there and they'll take the plea because they feel like they have no choice. And sometimes I'll have clients who refuse to take a plea, even though I think they should. There have been murder cases I worked on where I was telling my client, there's no way we're going to win this. There's just no way. There was a month-long murder trial I was involved in where I was telling my client the entire time to take a plea. Refused to do it. I'll tell you one more. There was one trial that I did where I had one defendant, and then there was a co-defendant, and my client was the accessory. My client provided the gun. And the other client did the shooting. The other defendant did the shooting. So there were 2 juries because they each gave statements, complicated legal stuff, but there were 2 different juries. One for my client, one for the other one. The other jury came back within an hour with a guilty verdict and put that guy away for life without the possibility of parole. As soon as that happened, I went to the prosecutor and I said, all right, you got your shooter, make my guy a deal. And the prosecutor made a deal 18 plus 2, meaning 20. 18 plus 2 for the felony fire means 20. Why did I do that? Because after the first jury was dismissed, I ran over to them in the hallway and I said, hey, I was allowed to do this, by the way. Once they're discharged, they're fine. They're not talking to the other jury. I went over to them. I said, hey, just a question for you guys. What would your verdict have been for my client? And they all kind of looked at each other and they're like, oh, you did a great job. And I said, no. Okay, but what would your verdict be? And they all just kind of nodded and said, guilty. I said, thank you so much. I ran to the prosecutor. I said, let's make a deal. She offered 18 plus 2. They said no. The client refused to take that deal. I went and we spoke. And I was explaining, you don't understand this. You have to take this plea. Refused. My client was 34 years old at the time. Would have gotten out at 54, or actually a little bit earlier because years are really considered 10 months. So my client would have been out before, but probably by about 50. Client looks at me and goes, 20 years is life. And I said, no, 20 years is not life. 20 years means when you're 54, you go home to your family. Life means when you're 54, you spend the rest of your life in prison. Client came back about 12 hours later with a guilty verdict. The jury. Yeah, I'm sorry.
Yeah.
So sometimes it's a case-by-case thing. There can be a lot of things that go into this decision. But generally speaking, if the person A did it and B is most likely going to get convicted, which is most cases, to be honest with you all, then generally we try to work out a deal.
So Solomon, here's the $1 million question from Nina Stanek. If your client is guilty of a crime and tells you everything, meaning that he did it, but wants to plead not guilty, what do you do?
Great question. Who said that? Nina?
Nina Stanek.
Nina Stanek. Nina, that's a great question. It's a question that I probably get more than any other question doing the kind of work that I do. And here's the answer. Okay. We're not allowed to put a perjurer on the stand. We're not allowed to have a client get up and testify and lie. Okay, so that's number one. If we know somebody's guilty, we're not allowed to put them on the stand and have them testify that they didn't do it if we know that they're lying. So that's number one.
However, and by the way, but let me just cut you off. By the way, not everybody knows this. So some people think that they can tell their attorneys the truth that they're really guilty or that they're about to lie. And they think, well, that's just attorney-client privilege. Now you can put me on the stand and I can lie. We're not allowed to do that. So
that's why what I do is every time I meet with a client, I tell them, and this is what ethics lawyers will tell you to do. You learn this in law school. When you meet with your client, you tell them, once you tell me something, I can't have you testify to something else. So let's not talk about what happened. Let's talk about the evidence. And that's what we talk about. Here's the statement. Here's the video. Here's the picture. What are the possible ways we could explain this? And that's kind of how you discuss these kinds of things with your client. So the reality of the situation is, if we believe, or if let's say our client tells us that they did it, let's say our client says that they committed a murder. Fact of the matter is, if there's not enough evidence to convict that person, the due process clause of the Constitution is more important, in my opinion, than one murder. And that means that if the prosecution cannot prove the case beyond a reasonable doubt, that person walks free. Even if I personally know that they're guilty. If there's not enough evidence to convict the person, or if the prosecution or the police violated the Fourth Amendment to get evidence, fruits of the poisonous tree, they searched a car without a warrant and without any sort of reasonable suspicion or probable cause and found a body in the trunk. And then they're able to connect the person driving to the body, let's just say, and just kind of shooting out a hypothetical here. Fact of the matter is, in my opinion, the Fourth Amendment is more important than one murder case. And that's why what I would say as a lawyer, and this is how I view things, even if my client is guilty, as long as I'm not going to put my client on the stand and have them commit perjury, I will do everything I can to make sure that the prosecutor has proven their case. And if they don't, I will argue the law and the evidence. I'm not going to get up and tell the jury, my client's innocent. I never do that. What I argue is the prosecutor did not prove their case beyond a reasonable doubt. The judge says the law is this, and you showed them the jury instruction. This is the evidence. The prosecutor didn't reach their burden. That's it.
Yeah. All right. Here's the last question of the show, and I can answer this. Hi, Solomon. Are you going to be following the Donna Adelson trial? And I'll tell you, I'd love to have Solomon on for the Donna Adelson trial. Solomon is not. I mean, he may have it on, like he's while he's doing. Solomon's like a multitasker, so he'll be writing briefs and preparing trials and things like that, and he'll have something on the television going at the same time, which he'll glance up at once in a while. So he may have that going on with Don Adelson, but he's not going to be following the trial like I will be. But don't worry, he'll tell you that you're in very good hands, and maybe we'll have him on to talk about some of the clips or some of the arguments made in the Don Adelson trial. But unless Solomon all of a sudden decides to stop doing everything that he's doing, because he's a busy man. So I appreciate, Solomon, you coming on. Hopefully we'll do this again shortly again. And it was great. So thanks. Anybody who wants to,
this was nice.
All right. Anybody wants to reach out again, it's radnerlawgroup.com or email brothercounsel99@gmail.com for any potential inquiries for Solomon or myself. All right. Thanks, everybody. We'll see you next time.
Ciao.